Vanakkam. Good evening, everyone. It's my privilege to address such a distinguished audience and speak about estate planning, which is one of the meaningful aspects in our professional advice. I thank the organizers for the invite to this forum. Let us begin with the real situation. A successful client passed away unexpectedly. He has left behind his mutual fund portfolio worth over 5 crore. He had a trusted advisor, well-balanced portfolio, excellent returns. Everything seems perfect except one thing. There was no will. Family had to spend months together to execute certain documents, complete legal framework, collect succession documents before they could access the investments. Not because the advisor has failed, not because the investment has failed, because estate planning was never discussed. And this is the gap we are going to talk about this evening. As MFDs, you all are focused on SIPs, asset allocation, portfolio review, long-term wealth growth. Wealth growth is only half of the journey. The remaining half is wealth distribution. It is estate planning that enables the wealth built over decades by the clients reaches their families seamlessly and perhaps without any conflict or disputes. And today, estate planning has become more relevant because the value of mutual fund investments have grown significantly. Clients today hold multiple folios, online investments, demat holdings, investments through apps and platforms. And investment records are often scattered. Families struggle to locate these investments. Yet, many clients hold on certain myths and procrastinate in having a estate plan. The most common statement we come across is that I have made nominations, it will take care of. You all are aware that nomination only gives custody of the funds, not the ownership of the funds. The other statement I come across, my family knows everything, they will be able to manage. In reality, it is not. The family does not know anything. The family does not know the details of assets and investments held by the deceased person. Ask yourself here, everyone, have you informed your spouse, your children, your parents, siblings, details about all your investments? I'm sure many would answer no. They don't know anything. No wonder today more than 1,25,000 crores is lying unclaimed in the Indian financial system for over 10 years. The other myth is that my family members have excellent relationships. They will be able to figure out. But the real test of relationship is known when the inheritance arises. And there are many precedents in our society. In the absence of clarity, even the most close-knit families have found themselves in confusion on conflicts. Other myth, I'm young, just 40, 50. I look when I become old, when I become aged. Death does not know the age of the person. Young or old, it strikes when it has to be. Today, if you analyze through the medical records, the number of people dying due to heart-related ailments, sudden deaths, is more in the age group of less than 50 than above 50. And these people think that they are young, they don't need a estate plan. And most importantly, when we talk about estate plan, only men talk about themselves, not women. Today, women also hold the assets. Estate planning is not only for men, it is also for women. It is for everyone who holds the assets. So when the client passes away, the first person the family members contact often is mutual fund distributor. Do you agree with me? Yes. At that time, you are not just advisor for them. You are the person on whom they depend upon. So an MFD who understands the importance of estate planning offers or provides real value to his clients and his families. He will be able to earn their deeper trust, build multi-generation relationships, and most importantly, retain the assets across generations. So estate planning turns client's relationship into family relationship. And you need not become legal experts to talk about estate planning. All you need is little awareness. Perhaps 3 simple steps can help your clients and their families in a huge way. Whenever you meet the clients, ask them a question. Have you made a will? Is it difficult to ask this question? No. You all are my clients as of now in this hall. I am asking this question to you all. Have you made your will? Most of them are silent. Second, please review the nominations periodically. Ensure that nominations are correct and valid. When the clients approach us in the inheritance process after the demise of the investor, most of the times we found that the name and other details of the nominee in the records of AMC does not match with the nominee's identity proofs like Aadhaar or PAN. And families struggle for months to update all these documents. Until then, they don't have access to these funds. It may take 1.5 years in certain cases, we have seen. And the stress the family undergoes, they know that funds are lying there, but not able to access. And they believe that mutual funds are not good because when they need funds, they are not able to access it. My advisor is not good. Just because we as advisors, we have not given enough attention to ensure that the nomination is updated as per the ID proof. And next, third one, please nudge your clients to prepare investment summary. In the absence of investment summary, it is very difficult for the families to locate all these investments. Please prepare yourself all this investment summary. And remember, when you have this investment summary, your 50% of estate planning is done. What all next you have to do is that plug to whom you want to give all these investments to your legal heirs. That's it. All you have to take is one step, one thought, one step to initiate this action. These 3 actions: ask your clients, have you made a will? Review nominations, prepare investment statements, and update periodically. Is it so difficult? How much time this may take? Believe me, all this will not take more than 7-8 hours, which I have seen in my practice. The famous author Jeff Bezos says, life is all about minimizing regrets. Estate planning is one thing we need to do to minimize regrets in the future. For MFDs, estate planning is not just responsibility, it is also an opportunity. Clients support MFDs or who help their families during the struggle times, during the tough periods. Returns are forgotten, support is remembered. When you integrate estate planning into your practice, you become the trusted advisor, not just distributor. The most important starting point for all of us is to understand what happens when there is no estate planning. Obviously, in the absence of will or clear plan, ultimately it is the succession laws that determine the inheritance of one's assets. And the reality is that the clients leave their legacy to these succession laws which they have never read, never understood, never intend to follow. So as MFDs, our role is to help the client to take an informed and conscious decision than leaving their legacy to the default legal provisions. So with this premise, let us look into these succession laws briefly and practically, which will equip ourselves to initiate meaningful discussions on estate planning. So the next few minutes, we look at these succession laws. Can I have the slides, please? So the succession laws we have in India is Hindu Succession Act 1956, Indian Succession Act 1925, and Muslim Personal Law. These laws determine the rights of legal heirs. They also identify who are all the legal heirs and the rights of legal heirs. Hindu Succession Act applies to Hindus, Buddhists, Sikhs, and Jains. When I say Hindu, it includes Buddhists, Sikhs, and Jains. Indian Succession Act applies to Christians and also the couple who belong to different religion and their marriage got registered under the Special Marriages Act. And Muslim Personal Law for Muslims. You see the complexity here in the beginning itself. Again, Hindu Succession Act has determined the legal heirs of male and female who are different. The legal heirs of Hindu male are grouped into three categories: class 1, class 2, and residual. The first right of inheritance passes on to class 1 legal heirs. In the absence of any class 1 legal heirs, then it passes on to class 2 legal heirs. If there are no class 1 and class 2, then pass on to residual. Let us see overall the class 1 legal heirs of Hindu male: mother, wife, and children. I am a Hindu. If I die without will, the rights on my assets will pass on to my mother, wife, and children equally. When I say children, both sons and daughters, equally. Is this your intention? Those who are Hindus here, note down this and think, is this what you wanted? If there are no class 1 legal heirs, then it will pass to class 2 legal heirs, not together. It is in the order of succession. The first will go to father. If father is not alive, then to brothers and sisters, then so on. It goes on. We don't have time to discuss so detail. But see, remember, the important point is that my father is a class 2 legal heir. As long as I leave behind my class 1 legal heirs, my father does not have a right of inheritance of my assets. My father will have a right only when there are no class 1 legal heirs. When it comes to Hindu female, The legal heirs are determined depending upon the source of acquisition of the assets by her. It could be self-acquired assets by her either before or after the marriage, or it could have been inherited by her on the demise of her parents, or it could be inherited on the demise of husband and parents-in-law. In each of these cases, legal heirs differ. See the complexity. Any asset which is self-acquired by Hindu women, those who are women here, please note down, whether before or after the marriage, on her demise, the rights will pass on to husband and children equally. Husband and children equally. She is married, husband and children are not alive, she has not left behind husband and children, then it goes to the legal heirs of the husband. That is, mother of the husband, mother-in-law of the woman, then father-in-law, then brothers and sisters of the husband, if you don't have a will. Hindu woman has not left behind husband or children, she is not married, then only the assets will pass on to parents. If this is your wish, just evaluate. Any assets inherited by Hindu woman on the death of her parents will pass on only to her children. In the absence of children, it will pass on to legal heirs of the father, never to the husband. Husband of Hindu woman will not have a rights to inherit the assets which she has inherited from her parents. If you wish to give to your husband, you must make a will. So the assets which she has inherited from her husband or parents-in-law will go to the sons and daughters or legal heirs of the husband. We are not aware about these laws. Most of us, we are not aware about these laws, but this is a fact. These laws exist. Right, these are about the Hindus. Then we go to Indian Succession Act, which applies to Christians. And also a couple belong to different religion. Of course, there is no male-female here. It is equal. 1/3 to the spouse, 2/3 to the descendants, that is children. I am a Christian, I leave behind my wife and a son. My wife will get only 1/3, my son gets 2/3. As simple. I don't leave any son. My wife and my parents, my wife gets half, my father gets half. So I'm just giving you to understand these issues. Okay? This I don't go. Then Muslim legal heirs, there are two types, sharers and residuaries. The first right will go to the sharers who has a definite share. Parents, wife have a definite share. And remaining will be shared between sons and daughters. Sons will always get twice the share of daughter under the Muslim personal law. 2:1. Sons get 2, daughter get 1. So you are aware when a person dies without a will, at least there must be a nomination to get access to the funds. In the absence of nomination, we need to have a succession certificate which is issued by district court, legal aid certificate which is issued by revenue department of the state governments. Sometimes we need a letter of administration. Very easy to say, but not so easy to get these documents. So when a person dies intestate, it results into disputes, complexities in resolving all these issues, uncertainty, there are expenses, and your distribution is out of control, not as per your wish, as per the law, and confusion, where to start, whom to approach, how to get all this process done. So the answer for this is, have a estate plan. So estate planning is nothing but a systematic approach to manage your assets during your lifetime and also plan for the distribution of assets after your lifetime. So why estate plan? It offers smooth inheritance of your assets without any complexities, avoids disputes, provide assets to the right beneficiaries, reduce expenses and cost and stress. So most importantly now, who needs a estate plan? If you have a tick mark for any of these statements, you need a estate plan. you need estate plan. If you have a tick mark for any of these statements. So how do we do estate plan? We have will, which we can draft or execute for the transfer of property after your demise. We can think about trust to protect your assets either during your life or after your life. And we have power of attorney to manage your property. So these are the instruments which we use in estate planning: will, family trust, and power of attorney. It is not the question that which is good between these three. No. All these three complement each other. In certain cases, we advise the clients to have both, all will, trust, and power of attorney. That is what is the need of the client. It is not that whether apple is better or orange is better. No. So ultimately, estate planning is not about the death. It is about the continuity beyond your lifetime. It is about ensuring that the peace and harmony which you wish is preserved among your family members. So as MFDs, our role or our task goes beyond returns and investments. We are not just advisors of wealth. We are custodians of clarity, guardians of legacy, and architects of peace. That is our dharma. Nandri, thank you. I hope I want